Hello, and welcome to a special program on a unique new initiative by the 12th Judicial Circuit and attorneys from ICARD Merrill to provide guardian ad litem services for the family division of the 12th Judicial Circuit. Joining us today to discuss the value and the scope of this new program are Judge Lee Hayworth, Judge Charles Williams, Robert Lyons, President and shareholder of ICARD Merrill, and Stacy Dillard-Spahn, member and ICARD Merrill coordinator for the 12th Judicial Circuit and the Family Law Guardian Ad Litem Pilot Program. Welcome, everybody, and thank you very much for being here to discuss this program. Judge Hayworth, when I first read about this program, I was very intrigued by the scope of it because this is a unique new program. Tell us about the genesis of this and why you, as a sitting judge, feel this is such a valuable program.
Well, I think all judges in our circuit have served in the family division, and we have always been concerned about the quality of the information we're getting from the parents about their children. And of course, the parents have lawyers and the children do not. And we have had a number of situations where it's become apparent that having an outside set of eyes and ears on the children would allow the judges to have a better result when it comes to deciding such things as time sharing with the parents, such things as issues of disputes between parents about education or health or other sort of issues. And we thought it was about time that our circuit did something to help the kids out in those situations.
Well, this is different from other programs, other guardian ad litem programs. And Judge Williams, how is that different from the existing guardian ad litem program?
Well, unfortunately, the guardian ad litem program has not traditionally been available in the family law venue. And as Judge Hayworth said, one of the things that really keep judges up at night is the best interest of the children. And we're always concerned about that. As I've said many times before, property issues and monetary issues in a divorce case, those don't trouble us as much as what's in the best interest of the children. So unfortunately, judges have to rely on a lot of things that they see in court that may or may not be accurate. Sometimes we have to take a chance that the person is telling us what's in the best interest of the children, and we have to believe them. This program gives us a unique ability to look beyond the courtroom, to see what's going on outside the courtroom. So when we say eyes and ears, literally, we're talking about the best interest of the child, represented by an advocate who's familiar with the justice system, who's sophisticated to know what to expect and to advise the child, and then advise the court what they feel is in the best interest of the child. So that's a unique program that's not traditionally been available to us in family law.
Judge Hayworth?
Charles, it's important to make a distinction here because we have had guardians ad litem for a number of years in the dependency section of our court system. That's under Chapter 39 of Florida statutes, and those are parents who've had their children removed because they've been abusive, neglectful, or they abandoned the children. We have an excellent program here, and that's staffed by attorneys and volunteer guardians, parents that come in and say we want to help kids in the dependency setting. This is different. This is in the family setting, and we've not had that before. And our model was picked up from one that we saw in Pinellas County, and we thought it was a good program. We thought it would fit well with what we're trying to do here in the way of providing quality services to the parents and the children that come into our court system.
And I believe it was just recently, in May, that you kind of initiated this program. Is that correct?
Yes. Judge Williams and I are the co-chairs of the Circuit's Pro Bono Advisory Committee. And in that capacity, we thought it would be about time for us to start a program that would do what we're talking about here. So we contacted a judge who is very experienced with guardians ad litem and family court in St. Petersburg, Jack Hellinger. And he and a very experienced attorney who does guardian ad litem work there through court appointments came and trained all the ones that you see sitting here, plus a number of lawyers from ICARD Merrill.
Well, one of the things that I want to talk about now is how ICARD Merrill got involved as the program. As you and Judge Williams sat down with the other judge from Pinellas and said, you know, this is a wonderful program, we want to try to get it initiated, it came to the point where, who do we contact? How do we outreach? And you went to ICARD Merrill, and tell us why you did that.
Well, ICARD Merrill is the only law firm that I know in our circuit that has what they call a firm plan, a firm-wide attorney plan, and I'll ask Stacy to tell you more about that. Mm-hmm. But what that means is that they have dedicated a large number of the lawyers in their offices, and they have a number of lawyers who will volunteer their time free, pro bono, to help people who need lawyers. And in civil cases, you know, they get a public defender in a criminal case, but not in civil cases. And when we looked around for a firm that had the reputation and the capacity to handle what we anticipated to be the volume, they were a natural choice because they've, for many years, dedicated themselves to that. And I think Stacy could probably explain to you how the firm-wide plan works.
And Stacy, it's got to be a tremendous, and Bob, the same to you, it's got to be a tremendous honor to be asked by the Judicial Circuit to pick up this pilot program and to run with it and to train your lawyers within the firm. So Stacy, first of all, you probably got the call first, did you? And said, how can we best serve?
Well, actually the call came to Mr. Lyons first as the president of our firm. So I'll let you take that one.
Judge Hayworth called me and described what he just told you, and I was intrigued. And of course, we have, through our program, worked with Judge Hayworth and Judge Williams and many of the judges in helping to deliver pro bono services. So when the judge called and kind of outlined this program, he said, I have this great idea, but we probably need to meet over lunch and discuss it. So he suggested that I bring Stacy with me, since he knew Stacy was prominent in developing our pro bono plan. So that's really how it started. We went to lunch with Judge Hayworth, and soon thereafter talked to the judges up in Pinellas County, and the ball just started rolling from there pretty quickly, actually.
Now, at this point, you know, within your firm, and I want to get into the training and the specificity of what each lawyer is required to do, but the ball was rolling right then, Stacy. And what was the next steps that you, as the coordinator of this pilot program, what were your next steps?
Next steps for me were to assess the interest in our firm with how many attorneys would be available and how many attorneys would be interested in doing this sort of pro bono work. Our firm-wide pro bono plan allows our attorneys to do a variety of different types of work. Mm-hmm. We've always tried to target those areas where the judges have identified a high need, where those folks who can't afford a lawyer they're missing that piece and they need that help. So we've always tried to keep close communication with them about where those needs are. For instance, we did a lot of foreclosure work when the foreclosure crisis hit. So when Judge Hayworth identified this as a need, I was really excited about it because I've had a personal interest in guardian ad litem programs for a long time. So I've been waiting for him to call and identify this as a need. So it was great that we got to do that, and I would assess the need, the interest inside our firm, and I had overwhelming support. Lots of attorneys responded saying that they were really interested in doing this. And I think the idea that you would get to help children was very intriguing to a lot of our attorneys. It was a way for them to feel good about what they were doing on a daily basis and helping children. And we got an excellent response.
If I may, I'd just like to read a quote from someone. This is a major commitment of ICARD Merrill time and resources. It is tangible proof of one firm's dedication to the oath we took as lawyers. Remember, when we were sworn in, all of us agreed that we would never reject the cause of the defenseless or oppressed. These children are defenseless and often oppressed. Few firms are willing to make the sacrifice of otherwise billable hours that these lawyers have made. It brings honor to the Sarasota County Bar Association and to our profession, and to have the ICARD Merrill attorneys volunteer for this project. And that was Judge Lee Hayworth. And that's really high praise, not only for your firm, but also for the quality and the caliber of the attorneys that volunteered to do this.
We are honored to be chosen to pilot this program and to take it very seriously. And I can tell by the interest of the attorneys and the training that we've put on that they're taking it very seriously and very, very anxious to get started.
One of the things, Charles, that's interesting there is the judge's use of the word firm. Because when we get involved in these programs, it's not just the lawyers. It's our secretaries, our paralegals, all of our support staff. It's a firm-wide commitment. We saw that as we worked through many of the cases that came to us as a result of the foreclosure crisis. We would have evening clinics, we would have Saturday clinics. Staff would come in to help us with the clients that we were servicing. So it goes beyond just the dedicated lawyers. It shows the commitment of the entire firm.
And I think that's a really positive thing, to have everyone trying to do their best in order to do this. But the question arises then is that what sort of cases do you get in family division, Judge Williams, Judge Hayworth, that require or that are very suitable for these guardian ad litems?
Well, you have to understand that judges make hard decisions all the time, and family law judges being no exception. However, we have determined that there are certain cases that we're going to call high conflict cases, in which there's something a little extra about these cases that require an extra set of eyes or ears to help us with. The actual definition of what high conflict may be, obviously you have to do that on a case-by-case basis. Right. We're also aware of, although we appreciate ICAR Merrill, we don't want to inundate them with too many cases. So the judges themselves will have to make that determination, and the lawyers hopefully will make that determination, actually what constitutes a high conflict. And maybe Judge Hayworth has an idea of what high conflict means.
Sure, I can think of an example. Domestic violence is child abuse in Florida. If a child is present when one parent is assaulting the other, that is by definition an abusive act on the children. Now, you're the judge and you hear that one party saying there was domestic violence, the other parent says no, there wasn't. Wouldn't it be nice to have a disinterested person talk to the child, go to the school, talk to the teachers, talk to doctors, which are all the authorities they have under the statute as a guardian ad litem, and try to get a handle around whether or not there's some value to that information, and whether or not they think that the child himself or herself is actually in danger because of it. And under the statute, the guardians ad litem can give a report to the court, they can request a medical examination of the children, they can get access to medical educational records. And so in a situation where the judge has some concern that an innocent child is being caught in the crossfire of a bitter custody dispute, the judge can then step in, appoint a guardian ad litem, and get some feedback from somebody other than the parents or their attorneys.
And that's very important. So it's an extra set of eyes and ears, so to say. Now, Stacy, let me ask you this, and Bob, the same question. I mean, is there additional training that you need or your attorneys would require to help you keep in alignment with the statutes that the judge just talked about? Absolutely. We had a half-a-day training in April that our attorneys attended, and it went through a variety of different subjects, from the statutory authority for appointing guardian ad litems, their duties, some training from the family court personnel who work with those folks who are involved in family court. But most importantly, I think the 6th Judicial Circuit brought Judge Hellinger and local attorney Belinda Lazaro, and they were extremely helpful in our training program because they got to tell us exactly what they were doing in the 6th Circuit and what was working. And it really helped us get through maybe some trial and error that we won't have to endure because we've had the benefit of them having been through the program. Extremely helpful in giving us good tips on how to speak to the parents, how to process the forms that we would need to utilize, giving us some assistance with that process. And we also had a local attorney, Jamie Wallace in our firm, who's a shareholder, provide some good background on family law. And we had Brad Broder, a local psychologist, come in and talk about issues of divorce and high conflict divorce and impact on the children. So it was a very eye-opening, enlightening experience for
our attorneys, because most of our attorneys attending that training session were not family law attorneys
Yeah,
and don't
that's-
traditionally practice family law. We do have several that do, but there were a lot that did not practice family law, and so this was really helpful. And obviously, Judge Hayworth was really helpful in planning that training as well.
Let me step in here and say, though, you know, the president of the firm tells Stacy, he thinks it's a good idea, right? So he turns to her and says, get on this, make it work. So we go to training, we got a binder about that thick. It's got the statutes in it, it's got proposed orders, it's got appointment orders, termination orders, material talking about what the powers of a guardian ad litem are. So she really worked behind the scenes to get together the things that we needed.
Right.
Not just ourselves, but the judges, but also the lawyers. Those that don't practice family law, they don't know what the elements are of a timeshare. They don't know the rules that apply that judges are looking at. So it was very helpful. So I don't want to downplay what she did, because behind the scenes, she was the one that put it all together.
Well, I would think that would be a valuable tool to have for attorneys to say, well, you know, what is the criteria that I'm looking at? Or, you know, what are the specificity of what I need to have, you know, to make, you know, good informed decisions? But the question then arises, you know, as a guardian ad litem, what authority do you, as a guardian ad litem acting on behalf of the circuit, what do you have? I mean, can you request records? Can you go to the school? Or, you know, what kind of authority do you have as a guardian ad litem?
It's a really interesting question, because the authority is very broad. The standard is the best interest of the child. So anything that you need to look at to assess what is in the child's best interest is very open. You have broad authority under the statute to look into just about anything that you think you might need access to, from the school records, speaking to teachers, speaking to other family members who are interested in that child, speaking to doctors, speaking to counselors. Really a broad scope of being able to talk to folks who interact with that child on a regular basis, and to get reports. Reports from, first of all, the court file is going to have a lot of information. Usually, I anticipate by the time we get appointed that the judges will have a good idea of why they needed a guardian ad litem in that case, and
Right.
reviewing the contents of the court file will provide a lot of information. But we really have authority to investigate just about anything we need to, with very few limitations on some serious confidentiality issues. But otherwise, if it's in the child's best interest for us to take a look at it, we should be doing that, and we have the authority to do so.
And that's got to be an important asset for a guardian ad litem, to have that broad spectrum of authority.
Let me give an example of an instance where having a guardian ad litem with those authorities would be very valuable to a judge. The parents are separated. They have 2 children, 6 and 8, that mostly stays with the mother on a time-sharing arrangement. The mother gets a boyfriend. The boyfriend is somebody she met online. They're living together now with these 2 children. Well, the guardian ad litem has authority under the statute to interview that person. The guardian ad litem can go look up in the county records whether or not that person has a criminal history. We don't have that information normally. Now, a party might present it, but the idea here is that we have somebody who is unconnected to the parties, going in, looking in. They can actually go in the home. They can see if it's a dirty house, whether there's hazards to the children. If you have an infant, there's not baby proofing. They can report back with that. If they have a pool that doesn't have a fence or some way to guard the children from falling into the pool, that's the sort of information a guardian get back to a judge. We won't have that without having people such as these lawyers who have volunteered their time to act as guardians.
Well, tell us a little bit, Judge, and Judge Williams, you as well, about the appointment of a guardian ad litem. You're looking at a case, there's custody or divorce or something. You know, what's the criteria that you look at for a criteria for that appointment?
Well, other than high conflict, the actual details of the appointment, I'm going to ask Judge Hayworth to answer, because there is a process and a procedure that we have put in place for that appointment to take place. So I'll defer to Judge Hayworth on that.
Sure. And I'm going to then pass off to Stacy and Robert here, because the way it starts is the judge can be the initiator. He or she can look at a case and say, wow, this definitely is a high conflict case. The lawyers can look at the case and say, gosh, I know what I'm coming into here. I really think a guardian would help. They can go to the judge. People that don't have lawyers can ask the judges if they would consider doing that. The procedure that we've outlined is that once a case has been identified by the judge as being eligible for consideration for guardian ad litem, he or she will set a hearing. At that hearing, the judge will discuss what a guardian ad litem is with the parties, explain what their powers are, request what we call a waiver of the hearsay rule, which allows the guardian to speak to people like teachers or counselors or therapists, doctors, and report back to the court without having to have those witnesses subpoenaed in to testify. And then hopefully before they actually have that hearing, they will have called Stacy. The judicial assistant would have called and said, hey, heads up, we got a case here headed to you that may be a high conflict case we need a guardian on. Then she's going to look at her files and make sure there's no client conflict.
Well, to take a moment there, I mean, there's a potential for conflict. If you're, for example, representing or your firm has represented somebody in the past, you know, there is always that potential for conflict, isn't there?
This is a good question for Bob.
Of course, and that was a logistical sticking point that we had to get resolved before we undertook this program so that we would have a system in place to deal with that. And as fate would have it, our firm has a conflict checking system, computerized checking system, so that when we get the call from the JA, judicial assistant, that says, hey, we have this case of Smith versus Smith, and here's the names and the addresses of the people, can you run your conflict check? We will be able to do that within a matter of hours and get back to the judge to let them know whether or not that's a case we'll be able to undertake, or if we're disqualified for some reason because of current or prior representation, even if it's on a different issue, maybe a real estate matter that we had represented one of the parties or both of the parties before. So,
but what an excellent way to do that, so you've eliminated any kind of conflict before you even undertake the case or the review.
Absolutely.
That's a great idea. So let me ask you this, is there a charge to the parents or is there a charge for this? And let's say that, Judge, you have a high conflict case and you've asked Stacy to look at this, and do you go back to the parents then and say, we're going to do this, but there's a charge? And how is that charge mitigated?
Well, we had that discussion. And in Pinellas County, which is the program that we're modeling, they actually do charge, and I think it's $200 an hour. They charge the parents that. Now, there are cases, of course, in Pinellas where they'll accept pro bono cases. We thought for this pilot project, what's important is to make sure this thing runs efficiently. Eichard Merrill volunteered their lawyers to perform up to 20 hours of free services for each case. And we're hoping that within that 20-hour time that they'll be able to resolve the issues that we need to have presented to us. But it's important for us to understand that that's taking them away from productive work in their law firm. And so we've asked them to make that sacrifice that you referred to, and it's part of the oath that we lawyers have all taken. And it's an important thing that the general public needs to know. Lawyers throughout this circuit are involved in dedicating their time and resources to helping people that don't have lawyers. And it is something that, lawyer jokes aside, they need to get credit for that.
So it's 20 hours per lawyer per case. That's a lot of time that your firm and your attorneys are putting forward. I mean, that's a lot.
We've had a firm pro bono plan in place since 2008, and we've provided 800 hours, between 800 and 1,000 hours a year, every year since 2008, from the combination of attorneys in our firms. Some years, some attorneys do more than others because a case requires it, and then it all balances out. But in the end, we're all providing those services because, first of all, it makes us feel good. I mean, we enjoy doing it. This is why we became lawyers, really. If you ask people why they went to law school, universally they'll all tell you because they wanted to have some sort of a positive impact on the world. They wanted to be involved in their communities, and they wanted to effectuate positive change through the legal system. So this is really something that renews their spirit as attorneys to be able to give back, and again, helping children. There's nothing better than that.
Judge, do you have a comment?
Well, I just wanted to say that one of the things that we've been doing traditionally is appointing lawyers who act as what we call attorneys ad litem. And attorneys ad litem have been extremely helpful, but they don't have the broad powers that the guardians ad litem have under Chapter 61, I think it's point 403. And because of that breadth of authority, the quality of work that we can get from a guardian ad litem is going to be better than what we can get from an attorney ad litem. No reflections on them. And they have been very generous in donating their time in the past. But we thought this was a way to upgrade it, and hopefully we'll be able to expand this beyond Sarasota County after we've had a chance to work out all the bugs. And we consider this kind of a shakedown cruise now. And we are very anticipative of having other lawyers join this program as soon as possible.
Well, and that would be my next question. The pilot program in Sarasota, and I'm sure that there'll be a volume of things that you're providing services to. But do you anticipate this, Judge Williams, going further, perhaps pilot programs in Manatee County or DeSoto County or other places?
Absolutely. The 12th Circuit encompasses Manatee, Sarasota, and DeSoto County. So ideally, we'd like all 3 counties to have access to this service. But someone has to be first. Someone does have to get the bugs out. And it's going to take a while before we perfect it, but hopefully, or get it close to perfection. And so we want to make certain before we expand it into Manatee County or DeSoto County that we've worked out the problems, some of them legal, some of them logistical. And we have no doubt that it will be expanded, and hopefully soon.
Well, if I could, I just want to take a few minutes to talk about the actual work that the guardian ad litem accomplishes. And, talk, as you prepare, Stacy and Bob, if you could, just jump in. As you prepare your work and you've looked at the case, those high profile cases that Judge Hayworth described, and you've talked to teachers and you've talked to different people about the subject, do you go into court as a representative, or do you testify on behalf of the child, or how does that work?
That could happen. We certainly have the authority to go to court and testify if necessary. But I think what's really important, and I keep emphasizing this with the attorneys, is we hope not to get there. We hope to be part of the solution. If a family is having a high conflict divorce and it's impacting the children, really what our goal is as the guardian ad litem for the child is to get those parties working together, everyone in the best interest of the child. And that hopefully can happen without utilizing a hearing process. If it's necessary to go to hearing, we will do so absolutely, and if it's necessary to testify as a witness, we will do so. But our hope is that by being a part of the process outside the courtroom, that we can get the parties working together. And that really important, it helps the court system, obviously, but the most important aspect of that is that when the parties are working together for the best interest of the child, that's going to be the best thing for this family overall and over the long run. You can't just solve this problem at this point in time because children grow and change. And the best thing is for those parents to have a good understanding that they're going to be able to work within parameters and get along together as the child grows and changes, and time sharing and the needs of the child change.
So in a way, you're like mediating, these different aspects, and you're bringing all this information saying, well, in your case, you need to stop doing this and start doing this. So you're kind of mentoring the families a little bit, or would that be kind of a correct assumption?
I don't think I'd describe it as mediating. I would describe it more as investigating and trying to find out really what the dynamics are in the family and reporting that back to the judge. We do have mediators, and that's a different role altogether, and we provide them at very low cost for people that don't have a lot of money in our court system. But one of the values that we have with guardians ad litem is their ability to access confidential information. Let me give you some examples. Let's say you have a family with a child who's 15 years old. It would be nice for the family judge to know that the parents had been in dependency court, and one of them had been found to be neglectful or abusive of the child. In that dependency court file, which is sealed or confidential except for the parties, the guardian ad litem in the family division can look into that file and see what did the judge say about this family in that context. Let's say the 15-year-old child was caught smoking marijuana or has an alcohol problem. the guardian ad litem can go into an otherwise confidential delinquency file and pull up that information and report back to the judge. Now, that report that she's referring to in written form is just as confidential as what was in the dependency and delinquency file. It comes, the clerk has to seal it, and so the judges can see it, but nobody outside can see it in a family case. Typically in a family case, if you go down to the court, you can look at all sorts of things. But one of the things you'll not see in that file is the guardian ad litem report, as well as certain financial information, which is excluded. So you can see the value that has to judges to have a global view of what's gone on in the court system, have somebody in doesn't have any axe to grind one way or the other, come back and say, well, I found this, this, and this. And if they have to report in court, of course, that could be in open court or in some cases closed court. But I think the value of that is very obvious, and we're lucky that we have now that ability to get that information.
So, and that information is just that. You know, there's no judgment in that. You should say in such and such a time this person, you know, was through dependency court. So you're just reporting that and accumulating that information that the judge can make an informed decision on.
That's an excellent point. That's something we stress with our attorneys. This is an objective process. Our job is not to make judgments. Our job is to be objective, to listen. I said listening is the most important skill here. Listen, investigate, look at things from an outside perspective. We have nothing to gain other than looking for the best interests of the child and providing the judge with all the information that he or she needs to be able to make that decision. Right. So being objective and not bringing your own sort of background or personality into it, but just being able to be objective is extremely important.
Now, Bob, how many attorneys are under this right now?
Well, we have 35 lawyers in our firm, and I believe we have more than 26 enrolled in this program already. And I suspect those who have not already taken up this torch will, after they're able to free themselves up to get the educational background, the training that we had to go through, which is only a few hours, but if they weren't available that day, they weren't
That's
available.
right, they have to come back, and
Right.
then Stacy's got to sit down with them and give them a whole...
Put an updated binder together, yes.
But is there plans to train more attorneys? I mean, do you want to train more?
Well, actually, we anticipated that because we called our IT department at the court and they came and videotaped our presentation so that when we're ready to roll this out to other lawyers, it'll be a lot easier and they can use that as an asset to help train the folks, and we think that's going to be very, very useful for them.
Well, the next time you have that and Stacy does it, maybe you can call METV and we'll come down and tape it as well. But I mean, I think that's an excellent opportunity then for that. Stacy's presentation will be available for a wide variety of people, perhaps with other firms, if you wanted to share that.
Well, my thought is too that we may supplement that. In other words, we may have them view that video and then come in and say, oh, by the way, this is at the beginning of the program. Mm-hmm. We've learned a lot more, and here's some additional things. Right, this is 2.0 or whatever.
Well, I think that's really critical because one of the things that, you know, Judge Hayworth, Judge Williams, I'd like for you to comment on is the significant need for the guardian ad litem. You know, the case numbers that you have in family division that would require this sort of help or assistance each and every year. I mean, do you anticipate a growth in this where you'll need more attorneys and a wider variety of people to assist you?
Absolutely. Again, this is a luxury item for us. As family law judges, what we love to do is to keep the child out of the proceedings as much as we can. It's not encouraged, but it's possible that a judge could actually talk to a child about the situation that they're in, but it's sort of discouraged and we don't like to do it. I think people lose sight of how traumatic a divorce situation can be, not only for the adults involved, but specifically for the children. So with having guardians ad litem, especially the skill set that attorneys bring to the position of guardian ad litem, it's really going to help us. Number one, they know the law. Number two, they know the process. Number three, they're used to taking a position if that is necessary for the best interest of the child. And so we feel that the skills that the lawyers bring are specific in terms of what we need as family judges to make good decisions. And that's what we try to do every day, make good decisions.
Judge?
Well, you know, Charles, I'm serving now in the juvenile division of circuit court, which involves dependency and delinquencies. And we have a wonderful guardian ad litem program in the dependency court. And I can't tell you how many times my decision has been influenced by the accurate, impartial opinions of these guardians ad litem. And not having that in family context has really been disappointing. And so we're looking forward to a new era where at the end of the road, the children will be better protected. We will reach a result that is more consistent with what's in their best interest. And as Judge Williams said, we can sleep better at night, because those worry judges that perhaps we're making the wrong decision. Let me add too, Charles, that there are limitations on the guardian's authority. Some of the things we cannot do, and Stacy, you can jump in here if you remember any exceptions that I haven't mentioned, but we don't get access to any medical records that involve the child testing for HIV or sexually transmitted diseases. Or there's this thing in Florida that judges are called upon to, what we say, if a young woman gets pregnant, she's under the age, we can issue what we call a waiver of the parental notification. It's a Florida statute where basically a young woman can come in and, without her parents knowing about it, get a waiver of their consent to have an abortion. Well, that sort of highly sensitive information, by statute, we cannot access. That's what they tell us we can't do. Now, in a serious case, I suppose it's possible for the parent or the child to be notified that there is an issue here that we'd like to look at. But before we even go there, we have to have a hearing, right?
Exactly.
So how would the firm handle that situation, Stacy?
If we were in a situation where the guardian ad litem felt they needed information that was highly confidential and we needed a hearing, we go through a process where we would request that a hearing be held, and there would be potentially, depending on the age of the child, there might be an attorney ad litem appointed to represent the child, particularly if the child's older, an older teen. An attorney ad litem actually then represents the interests of the child's position, which is different from the best interest of the child.
Correct.
So we could have that person come in and talk to the judge about whether or not that child is mature enough to make a decision about keeping certain highly sensitive information confidential. And it's important to note that we respect the level of maturity that children can reach as they age, and have that hearing and that process ready for them.
And it's up to the judges to make that determination whether or not to release that, whether, for the guardian ad litem's report.
Exactly.
And that's your decision.
Right. The child has rights of privacy, and the judge cannot intrude in that area without following certain due process requirements. And one of the areas that's very much protected is mental health therapies and counseling. Let's say a child has been referred to a therapist and has made all sorts of disclosures and things for a couple of years.
Right.
That child has a right to object to that. And so in order to consider whether that consent needs to be reviewed, we'd have a hearing. And in that case, excuse me, the guardian ad litem would have to wait for the appointment of an attorney ad litem to talk to the kids and say, they want to hear what's going on here. We can keep it confidential. You still can agree to keep this private or not. And then the judge can make a decision whether or not to keep that in a confined space and review it or not. And then if the judge does that, the child doesn't like it, attorney ad litem can appeal.
So, but the process is open in the best interest, where everybody has a voice in this.
Exactly.
The child, the court system, everybody has a voice, and it's up to the judges to make that final decision. I'd like to take a few moments, if I may, just to talk about the feedback, Bob and Stacy, that you get from the attorneys that have taken this program. Many, as you mentioned before, are not family law attorneys, but have undertaken this due to the fact that they want to give back and they want to contribute. What sort of reaction have you got from your attorneys that have represented some of these as guardian ad litems. Bob?
Well, we're of course just at the outset of the program, and I think the feedback is obvious just in terms of the number of people that have expressed an interest to do this. From a personal standpoint, since I volunteered to take the first case, I've got butterflies in my stomach waiting for it because I'm not a family lawyer. I've never been engaged in the family law arena, and so it's all new to me in terms of what goes on in family court. Now, I trust that my legal background, as Judge Williams suggests, is going to be, of some help. I would suspect that being a father of 4 is going to be of some help. And I know that the family lawyers in our office, within our office, who have expressed great interest in helping us monitoring us and kind of mentoring us through the process, is going to be a big help and a real assist. So from top to bottom within the firm, I think everyone's excited about it, and we're eagerly awaiting the real initiation and baptism by fire.
Yeah. And Stacy, you're right there on, with the attorneys, doing that. What kind of assurances do you give them by, providing them with preparation or insight, to help them meet those challenges of something perhaps that they haven't been involved with before?
100%, that's my job. My job is to make sure that they aren't concerned about the pro bono work that they do, that doesn't become something that it becomes negative. So my first criteria, this should be something that you feel good about. Mm-hmm. This is something that you should feel positive about doing. Right. And if you have any questions along the way, we have all kinds of folks that will help you. We have psychologists, local psychologists who have agreed to provide, feedback, training. If you have a question, it's a difficult question, maybe you can run in a hypothetical format without giving any names, run that situation by an expert and get their opinion on maybe a different thing that you need to look into, maybe a different person you need to talk to, or maybe some additional questions that you might want to ask the child. So I have assured them 100% if they have questions, we are going to help them. We're going to give you the support you need. We have our family law attorneys. We have Art Ginsberg and Jamie Wallace are highly experienced family law attorneys, and they have been generous and agreeable to talk to any of our attorneys about any issues that might arise.
And we don't doubt that as people are engaged in this process, there's going to be a couple of people who, after they go through it, say, never again. Find me something else to do. Sure. Find me some other pro bono outlets. Because,
other than family law.
Other than family
exactly.
law, because, as the judges have suggested, this is high conflict, difficult, gut-wrenching cases in some instances, and that's not going to be everybody's cup of tea, I'm sure.
And I would give Bob the advice I give jurors. The best tool in your toolbox is common sense. Mm-hmm. And if you use your common sense, that's the most important thing, and that's what we ask the guardians at Litem to do, not only in this program but in all programs, is really you're the voice. You're the voice for the person who's silent in this proceeding, and we're confident, I'm confident, that anyone in this program who uses their common sense is going to be of benefit to the courts.
Judge Hayworth, did you have a comment?
I do. Well, one of the hurdles we had to overcome was the fear that lawyers who do personal injury, contract law, real estate law, securities transactions, how are they going to feel about taking a family case? Mm-hmm. And that's why Mr. Lyons' leadership in this was so important, because he's a mediator, and that's what he does for a living. He also has trial practice as a background, but he's now mediating. And so trying to talk to somebody who, probably skipped the family law course in law school, suddenly being given this. But what I think is important for them to know is the guardians that we use in the dependency side are not lawyers. They are parents.
Right.
And as Judge
community
Williams,
members, people that have an active interest in providing some kind of guidance.
And they have common sense, as Judge Williams says, and that's really the primary quality that we need. So the fact that you're a lawyer, that helps. The fact that you may have had experience with family cases, that's also helpful. But it's no way an essential requirement for serving as a guardian ad litem, either in family court or in dependency court. And if any of your viewers are interested, I would encourage them to sign up and be a volunteer for the guardian ad litem in the dependency court, because they still need people there too.
And that's an excellent point. But as a follow-up to the question I asked Stacy and Bob, I'd like to pose this to both you and Judge Williams, Judge Hayworth, is how does the Judicial Circuit feel about this program? What are the expectations that you would like to see as a result of this pilot program, and what do you see the challenges being? Judge Williams?
Well, I can tell you the judges are excited. Even before, just the whisper of the rumor of this program lit up the phone in my office. Like, when does it start? When can we start giving cases? Is it up and running? So the enthusiasm is very high in the circuit. Remember, we only have for each county, we only have, and in DeSoto, we only have one judge that handles family law, but for Sarasota and Manatee, we only have 2 judges. Think about all of the cases that involve children and dissolution of marriages that come out of Manatee and Sarasota. So we need all the help we can get. So we're very, very enthusiastic. We're very, very happy that ICART Merrill has taken us on, and we're hoping for an expansion. Because ideally, in an ideal world, we'd have them in every case. But we realize that that's not possible. But if you ask me what our goal is that we never lose sleep over making a bad decision. And that's a goal I think that hopefully we can achieve with help like we're going to be getting soon.
Judge Hayworth?
Well, when we let it be known that we were considering this program, the 3 judges in Sarasota that do family law, Judge Robert McDonald in South County in Sarasota, which is at the Northport or the Venice Annex, Judge Curley, Rochelle Curley in Sarasota, and Judge Deborah Riva were, as Judge Williams said, very pleased to hear that they had another tool in their toolbox to help with children. And when we announced that we were having a training at the ICART Merrill office on this, we had Judge McDonald and Judge Curley show up with their judicial assistants, and Judge Riva was on vacation, and she was very upset that she didn't make it. So we briefed her afterwards. But the point is that there's a great level of support by the judges because we see the value of that. Mm-hmm. And I'm hopeful that they won't want to change divisions after they get a couple of these guardian reports in. But I think they're going to find it as a very important complement to what they're trying to achieve, which is looking at the best interests of the children, mm-hmm. making sure that they're safe, and making a decision that will be in the best interest of that family.
Well, Judge Hayworth, it sounds like a wonderful program. I want to come back to this probably maybe in a few months and to say, how successful it's been and, some of the challenges that you've overcome. And we've only got a few minutes left, and I want to kind of go around the table right now and get your, your final comments on why not only is this program important, but, what do you want to see out of this? And Stacy, if we may, we'll start with you.
I think one of the most important aspects of this program is that we can help give the judges information directly from the children. We can speak to the children and provide that information to the judges, and that child does not have to endure the trauma of coming to court. We don't want a child to have to come to court and testify. As Judge Williams noted, that could be a very traumatic experience. And so the judges miss those pieces of information that they need, and being able to provide that assistance to the court is invaluable. But ultimately, it's our commitment to the community and our commitment to the children in the community and helping them in a process where we can be of assistance with their lives and hopefully make them better.
Very well said and very eloquent. First of all, Mr. Lyons, you're to be congratulated for taking the lead on this at ICART Merrill, and stepping up to the request of providing this service. It's a remarkable step for a law firm to take and to recognize that giving back is an important commodity.
Well, thank you, and I'll accept your remarks as a congratulations for the entire firm, because that's the culture that we have. Sure, we are told as lawyers that we need to do a certain amount of this, but at ICART Merrill, and I've been with the firm for over a quarter of a century, it's the culture. It's the culture in which all of our attorneys thrive in and are eager to perform in. And it sounds trite to say it's a way to give back, But you know, in the final analysis, as lawyers, we lack the opportunity to sometimes see that we're accomplishing something good. And with this program, I'm hopeful that we can eventually see that we're helping to shape the lives of some young people who might otherwise not really get the attention that they should have, not have everything heard that should be heard, not have everything uncovered that should be uncovered. And so I look forward to that, and that's, I think, the best part of the program for me.
Thank you. Judge Williams, you know, there's challenges ahead with a program like this, but it's really a bold new initiative. You know, as a judge, you know, what are you looking forward to in this program?
Well, you know, the first thing I want to say is that I consider judges to be public servants. I also consider lawyers to be public servants. And when you can have an impact in your community, and people don't realize the impact that lawyers have in their community. You hear so many negative things, you don't pay enough attention to the positive things. But when you think about what they're doing and the positive impact they're having in their community, it really makes you feel really good about what you do. What I'm hoping for, which is what I think will happen, is that Sarasota is going to be a better place. Eventually, Manatee County, when they get this program, they're going to be a better place because of what we're doing. And that's the highest calling, I think, for lawyers and judges and those who serve the public, is to make the communities they live to be better. And this is an example of doing that type of work.
Thank you. Judge Hayworth, we saved you for last, you know, because I want you to, you know, you've put a lot of thinking and care and attention into making this happen. What's next? What's next for the program?
Well, what's next is to make this thing work efficiently and fair for all the people involved, especially the children. And I'd just like to close with saying, if I could, that there's very few opportunities that we in the judiciary have to establish a program that doesn't cost money. And this is an example of the commitment that lawyers have made to their community. It's proof positive that it's not all about making money. You don't ask an electrician or a plumber to give you 20 hours of free service when your sewer backs up. But these lawyers have dedicated themselves to doing that. It's an example of what other lawyers are doing throughout our circuit. And I can tell you, when we announced the program, and there was an article in the newsletter of the Sarasota County Bar, I got 4 or 5 calls from lawyers saying, "Can I get on the list?" And I said, "You got to wait. We got to make sure this thing works." So we're very pleased to have it at least launched, and to some degree we're building the airplane in mid-flight, but I think it's going to work, and I look forward to having positive results.
And Judge, you know, I just want to, you know, take one moment, you know, and Bob, I'll pose this to you first. If people want to find out about this program and what iCard Merrill is doing, how can they get in touch with you? And we're going to put the information up on the screen. Tell us how they can do that.
Well, they can certainly call our office at 366-8100 and ask for Stacy. She is really the guru behind the program. She knows the ins and outs of it and has really developed a workable scheme for us. And I'm sure she'd be able to talk to anyone and help them with that.
Do you hear that, Stacy? We're going to put the number up on the screen, 366-8100, and they're going to ask for Stacy Dillard Spawn if they have comments about that, or perhaps how they can get involved in this program as well. And Judge Hayworth, one final question for you. For people who want to find out about the 12th Judicial Circuit, or about this program, how can they do that?
Well, one thing we're going to do after you get this thing wrapped up, we're going to put it on our website. So hopefully anybody that wants to come look at this program, we'll announce it on our webpage, and I think you have the on the screen. www.jud12.floridacourts.org, is that it? That's it, and there's also a lot of other information there that would be useful to people involved with the court system.
Well, Judge Hayworth and Judge Williams, first of all, congratulations on doing this program and initiating this and reaching out to the community to try to get this program started. You know, kudos to you for doing that. But especially to Stacy and Bob for doing this program program, for stepping up when asked, to contribute back to this community. I think it's a lot of work, but at the same time, to have 26 out of your 35 attorneys step up to do this is remarkable. And I think from the standpoint of giving back and trying to do something for the benefit of children, it's really a remarkable achievement, and you're both to be congratulated for that.
Thanks. We look forward to it.
And thank you all for being here and doing this program. And thank you for joining us on this special edition. If you'd like to find out more information, go to those websites that we just listed so you can find out more. Thank you, and we'll see you next time on METV.